Good morning. I think the sign-in sheets are being passed around. We'll complete those and make sure each party gets one. I just wanted to go over the next meetings which have been publicly posted, and I have forwarded those by email to Craig, Johnny, and Carlos, and if you didn't get those public postings, please let me know and I'll make sure that you do get them. They're also available on the electronic bulletin board under the City Secretary's tab of the City of Corpus Christi website. Those dates that we had publicly posted were for Wednesday, March 25th today, Thursday, March 26th, Thursday, April 2nd, Friday, April 3rd, Wednesday, April 8th, Thursday, April 9th. We posted April 9th starting at 9:30, but if we need to, we have enough time that if we need to start earlier, we can revise that at least, as long as we have 72 hours notice, we can do that. We also talked about there may be an issue with the date Friday, April 3rd. We have a lot of conflicts on our end, especially because it's a Good Friday and a lot of people observe that, and so I believe we've agreed to cancel that date for right now and try to make it up.
That's correct.
At another time. Okay. And then
That's the day, Friday, April the 3rd.
Yeah, it's Good Friday. We didn't realize that. We have a lot of people going out of town, so it might be just me by myself if we did it. The other dates that we're looking at for the week of April 17th are to confirm that we're available on the 15th, 16th, and 17th. April 17th being the last day of the bargaining period.
Mm-hmm.
We're also looking at tentatively reserving dates the week of April 20th, just so we have those done, and if we need to, we can publicly post them with enough time. If we agree to extend at that point, which I'm hoping we're making enough progress that, well, I think we will be making enough progress that we can try to finalize a contract around that time. Okay, if there's no questions on those dates and the meetings, I'll get back to you. I'll check with Delmar and we'll move on. I had requested previously a couple of things from the union, and you had given us some wage information, a chart with some wage information, and I just wanted to, you did state that it was incomplete, and I wanted to follow up if there's been any updates to that, and if so, if you can email that to us.
Okay, I don't know. I'll
Okay.
check with my team at the next caucus.
Sure.
And provide you any updated information that we have.
Also, another issue that we had asked information about, and just so you can talk about it in caucus, maybe we can talk about this information when we reconvene. But with regard to the proposed grievance procedure that we put out, we had asked for some information with regard to the union grievance committee, who it's comprised of, how it works, and I think we kind of.
Who's on the team?
I think we kind of discussed who's on the team, but we wanted more information about if there's any policies that they follow or any protocols or anything that they, like a checklist that they go through or anything like that. And y'all can talk about it in caucus, and then when we go over our proposal, because we've presented a counter proposal to that, we can get into the discussion about that a little bit more.
Yeah, I'm going to tell you, even before I talk to my team, I'm reluctant to talk about how the grievance committee does its job. I mean, that's sort of like me asking the city manager for information about how he goes about his business of communicating with the council, and I'm sure there's not any one certain way. And so you're talking really about the inner workings of the union process. I mean, the grievance committee is simply a screening device to eliminate grievances that the committee feels lack merit. A lot of firefighters bring grievances to the committee that are perceived wrongs, but they're not violations of the contract. So we, quote unquote, set them straight, and the grievance doesn't go past there. As many grievances as you see, there are at least as many, probably more, that you never see because they stop right there at the grievance committee. So I would need to understand from you why the city feels it needs more information than that.
And I'll be happy to explain that right now.
Okay.
Seeing as how we rely on the union grievance committee as part of the official procedure that we're proposing in for the new contract, they're kind of a gatekeeper. You know, in any contract, I would be reluctant to recommend anybody I represented to sign and agree to something that they don't know they don't understand how it works, or they don't know, you know, what kind of policies they use, or what kind of protocols, or, you know, that's the issue. The city is relying, the city and the union rely on the union grievance committee to be the first evaluators of these grievances. Usually when we have something like this, it affects everybody, the union and, you know, the firefighter, the association, and the city. You know, in other instances, we have a committee that's comprised of both people from both, say, the city and the union, or something like that. So that's why we're seeking information, so that we know what that step entails, that we understand that step, that there's no ambiguity with regard to that step. And that's really the basis for the reason. I can go into more detail if you want.
No, I mean, I understand that, and I'm just pushing back a little bit, because obviously when a union member approaches the union grievance committee, that's sort of a confidential communication. And, you know, it's not really accurate to say that the union is the gatekeeper for both the city and the union, because the union is actually the gatekeeper for its members. It decides when disputes are going to be presented to the city at all. If the union stops a meritorious grievance from going forward, the union is on the hook to the member via its duty of fair representation and can be sued. So obviously, we're, you know, we tend to err on the side of caution in terms of if there's a quasi-legitimate dispute, but the city really gets an opportunity to see it even before it goes to the grievance committee, at least in some cases, because remember that, I hope I'm not mixing up my grievance procedures here. I'm negotiating a few contracts simultaneously, but, you know, there's that informal resolution attempt.
Okay.
You know, and so a lot of times, a supervisor may well know about the alleged grievance even before we do. And although that's not necessarily the case, I mean, a lot of times they just come to a union officer who may be a member of the grievance committee and say, hey, I'm you know, upset because thus and such has happened and I want to file a grievance. And they say, man, that's not a grievance because it's not a violation of the contract. It may be unfair, it may be this or that, but, you know, it's not a grievance. And so it doesn't go forward. And that's kind of like the end of the matter. But you get several bites at the apple, obviously, both at the fire chief level and at the city manager level, to resolve the grievance before it ever gets to arbitration.
Okay.
And plus the individual supervisor level in some cases. So
okay. You brought up some good points, and you know, specifically the accountability of the union towards the firefighter, and that they may, you know, they have the firefighter would have the ability to sue the union, but you know,
even
I think
a
that's important.
non-member.
I think that's right, and that's right. I think that's why it's important that we actually have this discussion, because you know, a lot, you know, I may understand that as a lawyer, but you know, management, staff, etc., may not understand that. So that's why I want to make sure that we both understand what that grievance committee is, what it does, how it works in the process. And so I think it's really important that we do have this discussion and answer those questions, because the only thing I knew to ask was what is it, you know, and that's why I was seeking information. And now that we're having this discussion about it, it becomes a little bit clearer. Okay, you know, the union does have accountability that they have to stand up to, and that's, they have to be accountable to the fire union because of, the firefighter, because the firefighter may turn around and sue them if they don't feel that they're properly represented.
Right, absolutely. So that may even, you know, yeah, exactly.
Okay, so that was the reason for asking for that information and for trying to have this discussion, which I think we may have just a couple more questions on that, but I think,
I'll be happy to try and
Okay.
answer the questions, but in terms of like the internal workings of, you know, how they conduct votes and that sort of thing, I'm gonna be a little reluctant to do that.
okay. Let's see. Okay, those are the only questions I had on that information. Before we walked in, I don't know if you received my email, but I did email you the city's counter proposals dated today, March 25th, 2015 at 9 a.m. That's what they're designated as. And I emailed it to you, to Johnny, and to Carlos. Did you get those?
I did get it, and what I thought would be helpful to us is if you just kind of walk me through it.
Absolutely. In the email, I tried to outline what is in this document. I emailed to you, and I'll go over that really quickly. This document contains all of the updated all the proposals from the city, including updated counter proposals and things that we have identified previously as tentative agreements between the parties. The tentative agreements are identified in green, and I have those. I think I outlined them in the email I sent you. That's on page 2, the preamble and intent, page 3, non-discrimination, page 9, relief, page 10, reassignment from fire prevention, page 12, meal reimbursement, and page 48, conflict with civil service statute. What we're also doing is we go through this contract and draft our counter proposals. We're trying to identify additional, because there's so many little bits and pieces to these contracts. We're trying to find things that we can tentatively agree to so that we can whittle everything down. So we're still in the process of doing that as well.
Okay.
The counter proposals that you will find are identified in blue, and those would be found on page 6. Validity of promotional list, which I'm more than confident we can probably TA that particular issue. Page 10, promotional bypass. Page 37.
Hang on 1 second.
Sure.
Page 10.
Promotional bypass.
Okay.
Page 37, grievance procedures. And page 43, disciplinary procedures. And the grievance procedure and disciplinary procedures are kind of long, they have a big old process involved in them.
Right.
On top of these counter proposals, we are working on some other ones, so I do
And
anticipate trying to get some to you.
And
as
I
we
think
progress.
I'd given you new proposals on both grievance procedure and discipline on March the 11th, and is this a counter to that?
On the, let's see, for instance, on page, let me find page 37. Okay, on the top, I've identified, for instance, on top of grievance
I see.
procedures, I put that it's our counter proposal to your most recent, as I found it, most recent proposal was 3/11/15 at 9
Right.
a.m., UA 24. So I
Okay.
tried to identify it there in red, like, I identified if it's a tentative agreement in red. If I have a counter proposal, I identified it's our counter proposal and which counter proposal we're responding to. And if there's any I try to make it easy to follow, but if you have any questions, don't hesitate to email me or just knock on the door.
Okay, and so I'm assuming that this proposal that you're making today is pretty much everything that you would want to see in the collective bargaining agreement.
Well,
I mean, you're not adverse to including other things that are in our proposals that may not be in your proposals if we make the case and you decide to accept them.
we will still consider those. Right now, as I'm saying, we're
But these are
looking-
the issues for you.
These are the issues for us, that we identified the initial issues. We do see that, like, for instance, we did, counter to a promotional bypass issue, which we didn't put on the table, but you did, and we've now included it here. So we're going through that process, and just because it's not in this particular one today doesn't mean that it's not something that we would consider, although, we're still up to talk about it if you have the ability to make your case, so to
Okay.
say.
Oh, we have the ability,
Yeah.
ready, willing, and
That's
able
right.
to make our case.
And we're still continuing to work on some counter proposals
Okay.
that you know, some of them can get a little bit tedious, especially when you're trying to compare and trying to make sure that
Right.
we're following the right one. So, we are trying to finalize a couple of others. But if you wanna go through them real quick while we're sitting here.
Yeah, you know, your management rights is not yet changed. I know that, I had sent you a counter
Yeah,
on that.
and that's actually one of the counter proposals we're working on.
Okay.
So the reason I point out the TAs and the counter proposals that we identified is because that's where we're trying to, those are the new things we're giving to you and we want to talk about, and we're still in the process of going through the rest.
Okay.
Just because it's not in here doesn't mean that we're still, you know, we're
Yeah,
just
you're
gonna
not
say
willing
no.
to consider
Right.
it, yeah. Okay. What I would like to, some of this stuff is pretty self-explanatory.
I
Or as they
think-
said in Raising Arizona, explicatory.
I can raise a couple of points off the top of my head without going through the specifics real quick, and then you can go through them, and then you can look
Okay.
at the specifics. Validity of promotional list is pretty much the same, it does the year, it was just the issue of counting that year, so I think I took some of your language and the dates and et cetera, so I think that's mostly something that we can probably TA, here pretty quick. Promotional bypass, this is something that, y'all had put on the table.
Mhm.
It was in the old contract, and I think that the difference there was that although it in your proposal, although it followed, chapter 143, I think it's 036, if I recall correctly. It said something about that the chief had to provide a valid reason, but
For
not-
involuntary
For an
bypass.
involuntary, we changed that language to say his discretion, which would require a valid reason anyway, so that's the only difference, but, you know, when we talk about the chief's discretion, his discretion has to be reasonable and has to have a valid reason. So we kind of just encompassed it with that. We did give, the chief has to do it in writing and place his valid reason in writing. And I think the 10 days to appeal is triggered by the receipt, once the firefighter gets the receipt of that promotional bypass, which I would assume to be, which we understand it to be the written reason why he was bypassed by the chief. Okay. And then we also included on the the voluntary bypass. When somebody can choose to bypass, say, I don't wanna take that position, et cetera.
Mhm.
One of the issues that we had brought up was what happens when everybody that's eligible decides that they don't want to be promoted, and then so we're left with an open non-entry position.
That you can't fill from the
That we
existing
can't
list.
fill from the existing list. We put in there a mechanism that if that happens, the chief has discretion as to how he's gonna fill it, saying, okay, based on the operational needs. Saying if all the people, say there's 3 people that can be promoted, and they all say no, and we really need, and there's no other way to fill it, then the chief has the ability to say, hey, look, okay, I need you to fill this, and I'm gonna promote you whether you like it or not, you know.
Yeah.
Kind of deal, and that's just, that's what the mechanism we're trying to work on, that was just the issue we're trying to address. So I just wanted you to consider that and understand that, you know, that we had a valid reason for including that.
Yeah, no, I get that. You know, I would hope that would be pretty rare, but, I mean, that you would exhaust the list, but
That's
if
right,
it
you
does
know.
happen, it needs to be addressed.
And we did talk about that at length, because a lot of these promotional bypass appeals and issues really don't happen often, but it just takes that one time, you know? And so
Yeah.
that's what we wanna make sure that if it does happen that one time, that everybody's covered and everybody gets, you know, gets a fair shot,
Okay.
okay? So that was the major thing with the promotional bypass. On the grievance procedure,
Before you get to that, can we go
Sure.
back a minute and talk about the health insurance proposal?
Sure.
I realize that's not a new proposal now,
right,
but I just want to really understand. It's my understanding from talking to my team that the health insurance was a very contentious issue last time, and that some pretty significant changes were made to health insurance as a result of the last negotiation, and that the health plan has been working pretty smoothly. And so and you have what appears at first blush to be very major changes to the contract. And I'm just wondering if you could walk me through your health insurance and tell me, how does it change what the firefighters have under the current contract?
Okay, with regard to all the deletions that I explained, you know, that were in the old contract and that we deleted, the reason we deleted it was not to change the substantive part of the healthcare plan, or not to change anything at all. The problem was that we had so many pages in our collective bargaining agreement that were governed by the plan document itself anyway. And I think we emailed you the plan document, and it's like 100+ pages, you know.
Yeah, we got a copy of it.
Right. So the deletions of, for instance, like the benefit summary, and all, like, you know, the out-of-network providers and things like that, the only reason we took them out is because it's already in the plan document and it's governed by the plan document. Say, for instance, if we had something in there about out-of-network providers within a certain amount, you know, a certain radius, and it was wrong, it didn't even matter. It didn't matter what was in the contract, because the plan document governs anyway. So the deletion of the substantive parts of the actual healthcare plan was in no way intended to change the way the healthcare plan is right now. It's just basically to try to limit the stuff in the contract to what needed to be in the contract. For instance, how they calculated premiums, you know, how they address the OPEB and the GASB liability, which is included in the calculation of premiums, things like that aren't included in the actual plan document. But the plan document doesn't change. The healthcare plan doesn't change at all.
And so that I guess is my question. Like, I'm looking at page 23 of your proposal.
And unfortunately, Steve had a meeting this morning, and he'll be here this afternoon, so he can talk more about this afternoon.
Okay, but well, then maybe we ought to reserve this for that. But
I can answer the one on page 23.
Yeah, I mean, page 23, for example, had the actual premium cost for employees in city.
Right.
And what you replace that is, I mean, you've taken that out.
Right.
And does that mean that the city now could raise premiums during the life of the contract? I mean, they currently...
the city, if you read the rest of the contract, the premiums could change at any given time. The key part is that the city pays 100% of the employee premium, and then they pay another percentage, 50% of the dependent coverage. We do have the ability through the contract, and we've had the ability through the contract and through the plan as we negotiated it the last time, to at some point, if something happens, there's a trigger that allows for a premium change, but it's, you know, there has to be communication between the city and the association. There has to be a certain amount of time of notice. I think it was like 30 or 60 days, you know, things like that. So the only reason we took out the actual numbers was because, and I can't tell you, we would have to rely on Steve, but I can't tell you whether the actual cost has changed. The percentage
maybe address that.
Okay.
It would change. Our premiums change every year based on utilization. So, but what we're saying here is that it may change the cost to the city. The firefighter is still, the employee is not going to pay anything.
Yeah.
And will only pay 50% of the...
And 50%.
Right.
And what about the benefit?
They could go up or they could go down. You know, it doesn't, and so...
But you need to realize that even though they're paying 100% of employee only, it goes up for our retirees
Okay. Good point.
significantly.
And the reason that we were kind of hesitant about that, if you recall on the last bargaining session, there were certain concessions made in order to be able to fit this all in with the constraints that the city manager had provided. And that's why we're kind of looking at this as...
well, guys, let me understand what the changes are that they're making, okay? what about the benefit levels, you know, I'm looking at page 27, all the stuff that's crossed out. You know, does that mean that these things could be changed? Or, I mean, in other words, all the things in the summary plan book, could they be changed? Could it go from a $15 copay to a $30 copay or something like that?
You know, the intention of that deletion was not to change the benefits as they currently are, because it's in the plan itself. This provided a summary, and even at the bottom or somewhere in here it said plan, that, you know, no matter what it says, the plan document governs. I can't recall, and I'll have to look back, I can't recall if we had the ability to renegotiate that if necessary, if we had
Okay.
to, through the contract, but.
I'm looking at page 29, and this thing in black, the first paragraph in black, the city has the authority to restructure benefits with the exception of certain. Is that current contract language?
Yes.
Okay.
Everything is current. The only thing, parts in this first section that talks about the healthcare plan, the only things we deleted were the parts that are found in the plan document already.
Okay.
And I confirmed, Steve and I worked on that, and he confirmed that, you know, the parts that we deleted are in the plan document itself. Nothing changes with regard to our ability to do, you know, requests for proposals, renegotiate certain things as limited to just, you know, the contract. So to generally answer your question, no, we didn't intend to change what we already had, what both the parties already had. What we're trying to do is basically try to simplify the actual collective bargaining agreement and let the plan document speak for itself, because it governs anyway, and leave in the collective bargaining agreement the things that we collectively bargain that were outside of that plan.
Okay,
Okay.
and the last question that I have for right now is at the top of page 31, the Cadillac tax provision. I know that y'all in the past have used a consultant, Randy McGraw.
Yes.
And I deal with Randy in other contract cities. I haven't talked to him about y'all's situation because he's your rep. But have y'all consulted with Randy or anybody else? And do you think that there's a real possibility that a Cadillac tax on this plan will go into effect?
I have not personally consulted with Randy, but I can't speak to Steve or the benefits people who, I'm sure they talk to him daily, and they may have addressed this Cadillac tax.
Okay.
The reason we included this was kind of a starting point to start this discussion to see if this does happen, how are we gonna deal with this? Because it's really gonna, it may be a large amount, it may be a small amount, but we just don't know. The likelihood of this happening, as far as, in my opinion, is probably very, very slim. It's kind of a safety net for both of us to figure out how are we gonna deal with this. Our intention is not to say, you know, we don't know. I can't say, hey, the Cadillac tax is gonna be, you know, $50 million, you know, how are you gonna pay? Because it may not be, I don't know. I can't make that assumption. We don't know. It could be $5, you know, I don't know. But the thing is, we're looking at, okay, worst case scenario, if it's a major number, how are we gonna deal with it? Because, you know, we have budgetary constraints, we have issues with unfunded liabilities that we can't, that you know, we can't deal with and are unconstitutional because we have to budget for them, et cetera. The Cadillac, you know, the Affordable Health Care Act kind of makes it hard for us to even try to do that. But this is our attempt to talk about this and to try and deal with a potential issue that we believe has a very small likelihood of actually happening.
Okay. Yeah, you know, at some point, what I may want to ask is that we have some kind of, maybe a conference call with Randy or something, and so I can talk to him about this in your presence and just try to make sure that I get my own head around
Sure.
what are the, you know, what are the realities and what might it look like.
Yeah,
'Cause
and in fact, I think, you know,
this
there's
is a
certain
new
certain
one for me.
aspects of the Affordable Health Care Act that are actually changing as we speak. You know,
Sure.
and the Affordable Health Care Act may not even be in existence by the time we have to deal with this, which would be the best case scenario.
Man, I gotta disagree with you there. I mean, the Affordable Care Act, I think, I may be against the
Well,
tide.
and what I'm
talking,
talking, I misspoke, the Cadillac tax.
Oh, the Cadillac
From the,
tax.
from the Affordable Health Care Act.
I'm
yeah.
not confident this Congress can agree on, who to name as dog catcher, but.
And who to know, I don't know, who's to say, I don't even know, I know there's a lot of issues with the Cadillac tax itself, and I don't know what's happening with legislation on that right now. And who's to, who knows what's gonna happen, so it may be something we don't even have to deal with, which
That would
would
be
be
great.
the best case scenario, but right now, the fact is that it's there, it's a possibility. We don't believe it's a large possibility, but it's a possibility. There may be a dollar amount associated with it that we are not funded, and we don't know, how we can take care of that, so, we need to figure it out.
Okay.
And, so that's basically what that section E is.
Okay, well, that's my questions about the insurance. You had something you wanted to, no? Okay. Just strumming down through the.
So looking at Labor Management Committee, that's probably something we'll be able to, we need to counter propose to that too.
Yeah, I
And that's
think
something
I
I have
included
down.
that somewhere. I'll find it. It doesn't look very controversial.
No.
Okay.
Just a note, a Labor Management Committee that works really well could narrow a lot of these issues down for when we get to the table the next time around.
Sure, sure. And that would be great.
Mhm.
I mean, it'll be up to the parties after they get the agreement in place to make that work. And
But that's my hope.
Yeah, well-
That's what my goal.
what do they say? They say keep hope alive and
Yeah.
hope dies last. Okay, anybody else have any questions about this proposal right now? What I propose is that we go back to our respective caucus rooms and start working on counters
Okay.
and maybe checking with each other around lunch period or something like that.
I'm not gonna go into a lot of detail, but I just did wanna mention on the grievance procedure.
Yeah.
One of the major differences is that, you have included the city as part of the grievance procedure. The city's never been a party to the grievance procedure, had never had a remedy through it.
Oh, and you don't want to do that?
Yeah, we, at this point, our proposal, maintains that the association is the one that has the remedy through the grievance procedure.
My question to you is, like, why? I mean, you accused the association, for example, this last time of violating the contract in terms of approaching council. And, your remedy was to file a lawsuit. And that's the only remedy you would be left with at that point. And whereas grievance procedure is expeditious, can be expeditious. And final quickly, that lawsuit, although it's in abeyance right now, it could go on for 2, 3, 4, 5 years, and some of them do. I mean, so there's, not even a possibility of an expeditious remedy. And the problem that we had this time was that you guys kind of, engaged in self-help. And, we could quickly get to an arbitrator and let an arbitrator decide those kinds of things. I mean, I'm not rejecting it out of hand.
Right.
But it just seems to me that y'all are depriving yourself of a major.
Well, I think right now, if we were to be subject to the grievance procedure that limits our remedies with regard to the jurisdiction that's given to the arbitrator, there may be issues that the contractors breach, but outside of the provisions, and that would prevent us from being able to assert our remedies of the city. The grievance procedure is mostly utilized by the firefighters because they're the ones that are gonna file the most grievances. They're the ones that are the beneficiaries of all the provisions of of this collective bargaining agreement. The city's also a beneficiary, but what we do, oops, that fell down. you know, we're talking about working conditions of the firefighters, working hours, and other, you know, compensation. So,
Well, let me just say this, okay? It's not truly an either-or thing. Even when you have an exclusive remedy under the grievance procedure, it is also true, and it's pretty common, that when parties file a grievance, they also go into court, you know, and seek some sort of injunctive relief to allow the grievance process to take its place. It's called, in the private sector, it's called a boys market injunction and a reverse boys market injunction. When you do it, it's boys. When we do it, it's reverse boys. Don't ask me why. But in fact, that's kind of what I did when the city repudiated.
It's a girls' injunction.
Yeah, I got you. You know, I sought temporary injunctive relief, you know, although I filed a grievance over y'all's repudiating the contract. I also sought a reverse boys market injunction, you know, to stop the thing until we could get it to an arbitrator. And so all I'm saying to you is it's not an either or thing. And just think about it. I'm not adverse to taking it out. It hasn't been in there in the past. But I think it's a tool that allows the city to get these things resolved. But you also still have the ability to go to court to seek injunctive relief if you feel like you're being harmed in a way that the arbitrator cannot remedy.
Let's think about it a little bit more. Well, let us think about it a little bit more, because even though we do have the remedy to go seek injunctive relief at court, that's our only remedy we can go. I mean, if we go file a lawsuit on something we believe is a breach of contract, yet we're subject to, now we're subject to this grievance procedure, which is basically an arbitration provision within a contract, a court's gonna say, this doesn't belong here. You know, we want it, normally a court, if there's an arbitration procedure in a contract amongst parties, the court is gonna say, this arbitration procedure prevails. Anybody who files a motion to compel the arbitration is gonna win, if it's a valid arbitration procedure.
You're correct, but of course, the contract grievance procedure only pertains to contract violations. If, for example, you're charging us with violating our statutory duty to bargain in good faith, that would be a lawsuit, contract or no contract. That would still be a lawsuit. And most of the city's grievances with us tend to be extra contractual. You know, in this one case, you were saying, well, we're violating the contract provision about how we'll negotiate a successor. But even there, you could have gone in, if you'd been required to file a grievance, you could have filed a grievance, gone into court, sought an injunction. If you were right on the merits, of course I never think y'all are right on the merits. You've been right on the merits, court would have granted injunctive relief and ordered us to arbitrate before we move forward, you know, that sort of thing.
Well,
So,
take that scenario where we were dealing with a statutory duty that was reiterated in the contract in a certain way, you know, and that was our position, that we had not only a contractual obligation, but a statutory obligation. If we were to do both a grievance and then file the lawsuit, we would go to the lawsuit. I would presume that you would go and seek an abatement of that lawsuit until the grievance procedure was done.
well,
So then,
the whole
and that
question would
mostly
be, the whole question in the lawsuit would be your entitlement to temporary relief pending the grievance resolution. So
Right.
in this scenario, you would have filed your grievance, filed your lawsuit, sought to enjoin us from continuing to go to the council. And if you prevailed, we would have been enjoined from going to the council pending resolution of the underlying contract grievance, okay? I'm not suggesting that you would have prevailed, you know.
I understand.
We both had differing views of that. But if you had prevailed, we would have been stopped, and then we would have had to gone through the grievance and gotten a decision from an arbitrator about whether we truly could do that. That's how I think it would go down. Just like I went to the court and said, hey, they can't just nullify the contract, they gotta do these things, and we filed a grievance on it, and the court said, okay, I'm gonna grant you a TRO and set it for temporary injunction hearing. And then, of course, we were able to put everything in abeyance. But it would be that sort of thing.
Okay.
You know, what's good about all that is if, you know, you get some quick temporary indication from a court at least about you know, where you're headed. It keeps the parties talking. What we want to do is avoid breakdowns. And that's not to say that you can't do the same thing through a lawsuit necessarily.
I mean, and most of the time, especially here in Nueces County, it's mandatory through any of the courts that you file, whether it be district or county court, that you attend a mediation. You know, that they include that in their scheduling orders. It's
Right.
mandatory.
Yeah. Okay.
So, you know.
Well, I'll think about it too. You know, I gotta talk to
and
my
my
team.
issue is, this is my concern. You know, we have rights through the ability to file a lawsuit. We have rights to discovery. We have rights to do all this, these other things that we would need to, in order to investigate what, you know, the merit, you know, and try to support either what it is we're alleging or what it is we're trying to defend, you know, because it could be either or. And I think if we go to, if we're forced to go through a grievance procedure that's through an arbitration, a lot of that becomes very informal. We lose a lot of the ability to object and to, you know, to weed out certain things, and that's something that we would be giving up. And so,
Okay.
so
Okay.
that's
I
what
hear what you're saying. Let me think about it too.
Okay. Okay. Disciplinary procedures, that probably speaks for itself. I really can't remember any of the major.
The only thing
differences
that I gave you some counters, and I understand these are counters to those counters, so I'll look at it. But I think I may have even shot you an email about this, that I thought, well, if we're incorporating a quasi-discovery procedure in the two things, that we probably ought to line them up a little bit.
I did do that. I
Okay.
attempted, that was my, I think I did that. If I didn't, that was what my attempt was, where the discovery procedure, is basically the same, and we can, you know, the way it's organized, we can do it, exactly the same, but I looked and made sure that all the elements were the same in the grievance and the disciplinary procedure. And on that issue, the promotional bypass that's subject to an arbitration, I said that it would be, you know, use the same procedure, and I just pointed out the grievance procedure, which should be the same, you know. They should all mirror each other.
Okay.
It gets pretty confusing when you're in a grievance procedure and there's one small weird thing that's just different, and you forget to do it just because you think you're used to the disciplinary stuff. So
Okay.
we want to
Well,
kind of eliminate that ambiguity.
Let us go start looking at this then, and
Okay, and
let's
we'll-
check in with each other around the noon hour.
Okay.
Okay.
We will probably go to lunch about, we're gonna work and probably go to lunch about me. You wanna check in at 1?
Yeah, okay,
Okay.
very good.
You put fact finding board, because, but it's ER's crossed out. I'm like, the fact finding border, yeah, I'm like.
I did that when there was an apostrophe, just, it was quicker and
Right,
easier.
no, it was just funny when I was going through it real fast, it was like, we've got borders here? Y'all probably deal with borders.
What did y'all just give me proposals on management rights?
Oh, yeah, I emailed you 3 proposals. I thought I had more, it seemed like I was doing that much
Alternative
more.
hiring and labor management.
Yeah, management rights, alternative hiring and labor management committee, and I have the pages, I highlighted them on there, but I'll give you the pages just for your ease. I think I may have put that in the email as well.
Okay. What-
But page 4 is management rights,
Uh-huh.
page 6 is alternative hiring, and page 36 is labor management committee. And as before, they're in blue, but I highlighted them and I labeled them that there are 3:25, 15, 1 p.m. counter proposal to whatever the last proposal you had. I identified the last proposal that we're responding to.
Where does the day go?
Are we on, Ken? Yes. Okay.
Ready.
No, just in the morning, because it's continuing to open. Oh, you need to sign both sheets.
For the afternoon. Do you have a sheet I could sign from this morning? Well, Steve and I both just got here.
We'll sign ours.
I don't know where you put it.
I think we're the only two different, right? Did Yasmin give you one?
No.
She took it. She took it.
One quick question about the health insurance again.
Yes.
If I heard you right, your proposal, although it crosses out a lot of things, really is not proposing a substantive change in the status quo.
That's correct.
Okay. You're just maintaining the status quo, you're just trying to ungunk the contract a little bit.
We're trying to simplify the contract, and since the health care plan document governs, we're letting that speak for itself, and we're leaving in the collective bargaining agreement the stuff that we actually negotiated that needs,
I got
that's
you.
not in the plan document.
And you've updated it a little bit to reflect the new numbers on those.
Yes, that's correct.
I forget what you
As
call
far
it.
as I know, yeah, I think the last numbers that we had from the actuary were for 2014, was it September or October?
Mm-hmm.
Those are, I think the date may be reflected, we talked about those earlier, but we do, those were based on the actuarial study, so we don't have, we don't have like a fund balance, it's like a bank account that you can go look and see what's in there, because I think you had asked us that beforehand. We don't have the ability to, go online and check to see what the fund balance is.
Yeah, the actuary report is done every 2 years. And so we don't have one for this year. We did have one, 2014 was the most current one. We'll do another one in 2016.
Okay, very good. So that's 2014 numbers that you got.
Mm-hmm.
Plugged in the blend.
That last number that we plugged into yes.
But that number reflects the new healthcare plan, right?
Mm-hmm.
So the utilization and all that other stuff for the current healthcare plan was taken into account for those numbers. Because this healthcare plan went into effect in 2012, if I'm not mistaken.
Okay, so what do y'all want to talk about before, do you want to describe your new proposals to me?
Yeah,
or-
what we spent most of our caucus doing was trying to, we were finalizing some counter proposals, we're still working on some more, but we were able to complete, management rights, on page 4. Generally, I'd like you to just go through that. What we did was we took a lot of, we looked at yours, we simplified it, we consolidated a lot of that laundry list. So I want you to go ahead and look through that. I think we had originally had like 32 on the laundry list. You had cut it down to 18, and we consolidated, we looked through it, and we were able to cut it down from our end to 21. So,
Okay.
we worked really hard on that, and, we simplified it. It seemed, I corrected a lot of the redundancies that were in there, and I think that, it's close. I think it's close to what you had, proposed to us, so you just need to look through it, and then we can just kind of talk through anything else that's left.
We can. I'm concerned when we, not about the list per se, but about whether y'all really understand, or that's not the way to say it, whether we have a mutual understanding of what a management's rights provision does. I've said, and you've said, at the bargaining table, that a management rights provision retains rights that you already have.
That's right.
It doesn't give you anything.
That's correct.
And yet when we get to like the grievance procedure, then you say, well, if it's a management right, well then that's not a proper grievance. And of course, that always begs the question, because you're gonna say everything's a management right. Unless you're different from every other city I've ever come across in the world. And we're always gonna say, no, there's a specific provision of the contract that governs that, and there's the dispute. And that doesn't make it an arbitrability dispute. It makes it, you still gotta arbitrate. But But cities want to grab onto these management rights provisions and say, we don't have to arbitrate because that's a retained management right. Well, no, it's not. You know, it's retained if you didn't give it away, but that's the whole question. And that's what we got to arbitrate. Did you give it away?
Right.
And we have to point to a specific provision of the agreement, right?
That's right.
So, but I think it's important to keep in mind because, you know, when I go back to my caucus room, my folks are saying to me, my God, they got 21 things here that we're giving them. Well, no, we're not giving them anything. They're retaining rights that we're not otherwise affecting either by law, statute, the contract, city, heck, the city council can take things away from you when they, like, for example, when they establish the number of positions within a range, you know, then that governs, and you don't have a retained management right to, you know, affect that number anymore. The council did that. So, you know, I don't see a management rights provision as a particularly useful thing. Something falls in management rights if it's not otherwise affected by the contract. But I just wanted to have this discussion because I don't think we can say too many times that it's not a give of power to the city, it's a retention of powers that the city isn't giving up.
And I'll clarify it from the city's position. You're right. This management rights proposal that we have placed on the table and that we're working on together here is a retention proposal. We're not asking, you know, for you to give us something that we don't already have. We already have it either by virtue of being the city, by the authorities given to us, and authorities and limitations given to us by law, resolutions, ordinances, etc. So we're not looking to bypass any legal requirements or statutory requirements we're bound to. We're not looking to gain something we don't have. We're merely establishing that we retain all the management rights that we inherently have to begin with. The purpose of this collective bargaining under Chapter 174 is to allow us on certain subjects that are mandatory and certain subjects that we agree, you know, permissive subjects that we agree to bargain on, is to say, okay, even though we have these management rights, we're going to modify them and be bound contractually by certain provisions of this contract that we agree to. So what we're saying is, unless otherwise modified by specific provisions of the contract, and that meaning if you have agreements, you have to be able to point to a specific provision in the contract, that's going to be something that's grievable. If it's not modified by the contract, then you can't file a grievance. What we also included in here was the ability, we weren't also looking to get out of, you know, be able to do something and violate the law and then not have any recourse for it. We also included in there that we are also bound to be restricted by all applicable laws. And so even though we're saying that the management rights we don't modify, you don't have the ability, we're saying you don't have the ability to grieve it. We also say if you allege that we somehow violate the law or limitations that are placed on us, you can file a lawsuit or do whatever you need to do.
No, exactly.
So,
I'm very clear about that.
Right.
That the contract grievance procedures for contract grievance, you know, alleged violations of the contract. But I'll tell you what I am concerned about, and because it seems to directly contradict what you just told me. If you look at the last sentence of the first paragraph of your management rights proposal, nothing in this agreement is to be interpreted as constituting a waiver or restriction directly or indirectly of the city's authority, rights, prerogatives, management functions to operate as fire department based on, you know, certain that's like saying, okay, we have this contract, but nothing in this contract changes our inherent authority. See, that's a false statement based on the explanation you just gave me. Because what it means is, we've got these rights and nothing in this contract is being interpreted as a relinquishment. So if I say to you, well, we've got a provision in here that you're going to do a 24/48 work schedule, you say, well, but we have the management right to set work schedules and nothing in this contract can be interpreted as constituting a waiver.
Right, and
so I'm going to come back to you and I'm going to eliminate that sentence and I want to explain why.
Okay.
It's not an attempt to limit your ability to retain the rights that you have, but it's an attempt to make clear that that the things you do give away in the agreement, you actually do give away in the agreement. And it's the same with the very last sentence of the city's exercise of its retained inherent management rights is not subject to challenge through the grievance procedure. See, this is an argument we often have with cities. They'll say, well, you can't read that, that's a retained management right. And we're saying, no, Article 21, Section 2 applies to this and limits your retained management right. You say, well, no, it doesn't. We don't agree that it does. And we say, well, we want to agree. Well, you don't get to because it's a retained management right.
We actually took that last, if you continue on with that sentence, it does give the exception. When otherwise in conflict with a specific term of this agreement or applicable law. And that last sentence is actually, we took it directly from your last proposal.
You know, and I'm beginning to embrace it. So.
And I want to clarify, you know, when we're working through this language, I think the very important thing in having this discussion is to clarify what the intents are.
Absolutely.
And I'm glad that you pointed that out, because when we're in the caucus room and we're trying to look at 5 different documents and trying to make sure that we cover, you know, that we are going off the right counter proposal and that we're accepting some of your changes and modifying, you know.
It's hard.
It gets hard, and when I was drafting this, I was looking in the context of the entire paragraph, and that last sentence is supposed to mean that otherwise modified in the contract. So, if you want
No,
me,
and you're right. I didn't see the last phrase. You know, I often do that. My mouth gets a little bit ahead of my brain.
So
But,
I want to point that out, where, you know, everything here that's included in this management rights, and you may have a better command of the English language than I do.
Doubtful.
I grew up Spanish was actually my first language. So.
Oh, wow.
So, you know, if you have a better way to help me frame that intent, it's the way we retain management rights unless we give them away by the specific terms of the agreement.
Right.
And of other, you know, and we're also bound and limited by certain statutory requirements and law, and et cetera. And that's the basic thing. And I think we're both on the same page with that, and we just have to kind of finesse the language a little bit.
And we can get there. I mean, the only other thing I'll say about management rights, because we actually have made huge strides. The only thing I'll say about management rights is I see this as a package deal. You know, I know that y'all don't want a maintenance of standards provision in the contract, but to me, management rights, zipper clause, which you've asked for and haven't had previously, and maintenance of standards are all one big ball of wax. And so, I mean, I'm just presaging that for you. I think we can get to a common point, even given your antipathy to maintenance of standards. You know, I mean, I was looking in your police contract, and I know that they're up for negotiation this summer, where you've got a maintenance of standards provision in there. So, you know, I think the thing to do is to have some kind of a happy medium. It's going to be very difficult, if not impossible, to agree to a zipper clause without a maintenance of standards provision, because otherwise, you know, we'd have to have a couple 100-page contract to identify all the things that are important to us, and that's not workable. But what I think is workable is to come up with something so that you know, the maintenance of standards is used like a sword rather than a bludgeon. And I actually think that and we'll get to our grievance procedure in a minute, that the loser pays grievance system is part of that. Unions are not made of money, and they don't like to bring grievances that they don't think they have a legitimate shot at winning. And I was taken aback a little bit when you talk about the number of grievances that have been filed, but what I found out is that very few of those have actually gone to arbitration. And I would suggest that, you know, that's the reason. And, you know, we were talking earlier today about the operation of the Union Grievance Committee. I mean, there are actually many more grievances that are brought to us than actually y'all ever see. In fact, I was told one of those happened just today. So, anyway, okay.
Well, and I just, let me just respond real quick to that. The management rights provision or proposal has become very important and very relevant to these contract negotiations and to this particular new contract because of the history that we have encountered with the prevailing rights provision and the misunderstandings on that. I think I think we need to clarify what you really are looking for with the maintenance of standards provision, which used to be the prevailing rights. The way it has been previously used was as an attack to retain management rights. If it wasn't specifically stated in the contract, and even if it was, prevailing rights was always cited in grievances and always used as a ground for agreements and for contesting things that would be inherent managerial rights.
I hear you saying that, and of course, that's always the tension. Is it a managerial right, or has it somehow been given away in the contract? But I checked with my folks, and I'm talking off the top of my head, so my numbers may not be exactly right. But I think that there have only been 3 grievances that have been filed in the term of the current contract where it was a standalone maintenance of standards grievance. In other words, it was a grievance that cited a specific provision of the contract and maintenance of standards. Okay?
I do have
Am I
that-
right about that, guys?
I do have that information, and I would be happy, I was looking at it, I would be happy to provide you just with a summary of that stuff, and.
That'd be great.
That way we can look at it and we can both know what we're talking, that way we're,
Yeah.
I talk off the top of my head, but I'm not always remembering correctly,
Yeah, well, you and me both.
So let me do that. Let me get what I have as my summary sheet on the grievances, and I don't know how far back, because the prevailing rights provision has been in that contract since before 2012, and I think since I've been here, I've been dealing with it since at least 2011. So I'll get some information for you. You can verify it. I'll email it to you.
And Roxy, let me just ask you, and you may not know this off the top of your head, but how many grievances has the association actually won based on maintenance of standards?
None that I can recall.
You know.
But there is a significant amount of grievances, and my recollection is more than 3 that has always cited.
Well, no, I
prevailing rights.
understand what I said. I didn't say that there are not more than 3 that cite maintenance of standards. I said there are only 3 that are standalone maintenance of standards.
Okay, where
They
that's the
always
only
cite
thing that's-
primarily another
Okay.
article of the contract, and then they throw maintenance of standards in.
Okay.
Which,
And
you
that may
know,
be true. I can't recall, but the information will speak for itself, and then we can
Yeah,
talk
yeah,
about it.
absolutely. And, what I'm saying is if maintenance of standards is not preventing, and that's what I kinda like about grievances, is the union may have an understanding of a provision, be it a maintenance of standards or otherwise, and they haul off and file 5 grievances, but by God, they lose all 5. And now you've got a body of law that lets both parties know what that really means.
Well, and take for instance this last arbitration award that I recall just because it was the most recent one, where it was a grievance, and I can't remember the specifics, but it was based on a contract provision that stated one thing, but the grievant was alleging another, and he said he wasn't bound to that specific provision because of the prevailing rights or maintenance of standards provision, that it didn't apply to him because it was always a practice. And the arbitrator came back and said, no, it's a specific, you can't throw that in, and you can't go around a provision in the contract just because you're now claiming a prevailing rights. It was something that was specific in the contract, there's a
And I think
discussion
that-
about that.
yeah.
I don't think y'all agreed with, you've stated that you don't agree with it, but that is what.
If that's what
we
the
have.
arbitrator said, I think that most arbitrators would say that if you have specific, clear and unequivocal language in a contract, that even a practice of ignoring that contract language for a number of years normally won't overcome it. I think a lot of arbitrators will say that. That's a problem that you have with a contract like the one that you have right now, is that things have gotten stuck in there and people don't even know they're in there, much less, and practices gin up. And I certainly am not, I'm talking without talking to my team, so, but putting something in maintenance of standards that says that, maintenance, a practice won't govern over clear contract language. Because I think that's the law anyway. But, the devil's in the details. Let's look at your data and figure out what we've been doing.
Okay.
So, I mean, negotiations, like grievances, like everything else, it's all part of the learning process.
Okay.
So, these guys may be hearing stuff from me that they wish I wouldn't say. You know, almost all my marketing teams do.
That's true.
Okay.
Okay.
The-
So that was just the management rights, you can look through that. I really think we're close.
Yeah, we are, I do.
On page 6, alternative hiring, we accepted the way that you organized and redid the language. The only difference is that you, in your proposal, you stated that an alternative hire would have to possess either an EMT or a paramedic. What we're trying to, we're trying to utilize the alternative hiring process just as that, an alternative hiring process that is expedited in cases where we need to fill a position rather quickly. We think by leaving the pool with the people who are paramedic certified would really shorten that pool, and we're not requiring that they're already fire certified. We can still get that, but we can get that pretty quickly. And so that's the reason that we took out the EMT and we want it to be paramedic, because we want it to be an expedited kind of deal. We don't want it to be like a, if we're gonna do an academy, we just do an academy, and that's what we need.
Yeah,
So-
I mean, we were actually in that one trying to give you more discretion, and so you're actually telling us we don't want that discretion.
Yeah,
because
we
you could
just-
use the alternative hire and only hire paramedics from it, whether it said EMT or not.
Right.
But now you're limiting yourself to using it for paramedics, and if you decided 2 years from now, well, now it makes sense to bring in EMTs through alternative hiring, you're not gonna be able to do that because of the contract. And so, I mean, if you don't want the discretion, we'll be
Yeah,
glad
and
to.
our goal is to, as you have seen through our proposals, is have a certified paramedic, rank and file. And that's where we wanna hold that standard, and we would, we have the ability to set those academies, because, I mean, if we do the EMT and then we get them to do the paramedic certification, that also costs money, it takes a long time. And so we wanna shorten it.
Did you talk to the training division who actually trains these guys? Because at one time, we were pushing for paramedic only, and y'all were pushing for EMT. And then we talked to the training guys, and they said that under alternative hiring, when they hire paramedics only, it takes them almost as much time to retrain the paramedics to our standards than it would be to start with an EMT and train them to our standards anyway. So when we talked to the different training captains and the chiefs over there, they wanted us to go with y'all's idea of going all the way down to EMT. So based on that, we figured it would be better for them to start at EMT so we can train them to our standards, because the paramedics that come in right now are not at our standards.
Okay.
Let me, if you would give me a chance before we move on that, let me double check with the chief and the management and make sure, because I haven't discussed that with I haven't talked to the training people at all, so I don't know what you're talking about, but I know they have history and knowledge of that, so let me talk to them and we'll revisit it tomorrow morning, and
Okay.
I'll let you know.
And then on the labor management, I see that y'all have accepted our language from an earlier proposal. That's actually one section of the miscellaneous article that we proposed.
Yes.
So, but
It is.
we can know that.
It's one section, but, like I said, we're trying to
No. Okay.
whittle it all down. I did add I changed, like, for instance, I changed the word problem to issue. I think problem has a negative connotation. And,
Okay.
sometimes there isn't a problem, there's just an issue you need to talk about. I also added that last sentence, because I want it to be clear, the Labor Management Committee is a collaborative effort to work out issues. It's not to be used like an informal grievance procedure kind of deal. And that's just basically to protect the integrity of the Labor Management Committee.
Okay.
I
Let me
think that's
see,
what we
is
got.
that, I'm looking forward.
Page 36.
Oh, yeah, okay, yeah, we can, I'm sure we can work that one out. Do y'all have anything else on those three proposals?
No, those are
I
kind
wanted
of
to go
the
through
major
the two
deals.
that I provided to you folks, and because I do think that we're real close on them, and one more than the other. Let's do the impasse procedure first. That's the Article 28
Okay.
proposal that I sent you. Impasse procedure. The first, what I've done is I've taken my last proposal to you, and the changes to my proposal in response to your proposal are in blue and red. I don't know if it came out blue and red for you.
It came out all red.
All red, but underlined obviously is added, and I've made a number of changes in response to your proposal. The first one, in that subsection A, right there on the top of page 1, I have put in your language verbatim, but I've added a sentence at the end of it that I assume you will think kind of negates. I said, however, this provision does not prevent the association from meeting with city staff and city council members about unrelated matters or from making factual presentations to them concerning upcoming or ongoing negotiations. This was the big issue in our lawsuit, and of course I took the city manager's deposition, and the city manager indicated to me that he understood, as we did, that the association has always gone to the city council despite the existence of this language. And I can't agree to take from ourselves the ability to do that. The city has taken the position that when we go to the council to talk to them about issues related to bargaining, that we're engaged in bad faith bargaining. I would say to you that that's not true, that you're not going to find any cases in any jurisdiction that say it is bad faith bargaining for a public employee union to go to and try to talk to their constituent council members. That's just not a true statement. I don't know how to be any more blunt or forthright than that.
Are you saying a union or an individual firefighter?
I'm saying a union.
Okay.
It is not. It is likewise not an unfair labor practice for management to hold so-called captive audience, conferences with the members of an association, as long as, obviously, there are no threats, et cetera, et cetera. And that goes both ways. I mean, we're not allowed to threaten people any more than you are. But what this really is it's closing a conduit of information to the council members. And I'm not talking about individuals here, I'm just talking about the system. Obviously, if the only message the council members get is a message that's from the city manager, they've got only one viewpoint, and that viewpoint may or may not be correct. And if there is factual misinformation that's going to the city council from the city manager or any other source, we have to be able to retain the ability to respond to that. I think the First Amendment, as Frank said famously on tape, we do have a First Amendment right to do that. It is a violation of our First Amendment rights to suggest that we should not be able to do that. Obviously, we could waive that contractually. We could. Why would we? I mean, what that does is it doesn't create a good faith bargaining aspect. What it creates is a lopsided bargaining, where the decision makers may actually be deprived of factually correct information in making decisions about a contract, and that is a recipe for disaster. That doesn't prevent the city manager or city administration from saying to the council, I don't want you to talk to them. And if the council members decide to honor that, so be it. So be it. I mean, we can't control the council members any more than we can control our own members, and God knows we can't control our own members. But I don't want this to bog us down. I mean, this whole paragraph doesn't need to be in the impasse procedure. you know, we can negotiate ground rules each time we negotiate the contract and make those decisions then about what's fair game. But, you know, you're really asking us to negotiate with one hand tied behind our back. And that's, I think, unfair. And so I know that we may have to agree to disagree about that, but I'm hoping that you're not going to let us bog us down, because this provision aside, I think we're on unanimous agreement on almost every other aspect of the impasse procedure, because I've come to you on almost everything. If you look at section 1, I'm looking at subsection B now. Section 1, I've added in response to your proposal that at the dispute conference that only upon mutual agreement will a permissive subject of bargaining be included on an agreed list of disputed issues. Okay? Everything that's in black essentially is, you know, agreed language. We may not state things exactly the same, but, you know, if we look at the top of page 2, I've eliminated mediator from the FMCS. We certainly could use one, but we're not bound to doing that. And of course, mediation is only by agreement. I've added a thing at the end of it to be clear that if things stay TA'd, those TAs are going to become part of the agreement. And that's actually in response to a lawsuit that we had a few years back, where in a different city, we had like 20 TAs and 4 unagreed things. We went to arbitration on the unagreed things, and then the city claimed that none of the 20 TAs were part of the agreement. So I just wanted to make clear about that. We've agreed on fact-finding in section 3. We've agreed to the 3-member fact-finding board concept, with each side picking one and those 2 picking the third person. That's in response to your proposal. And what I've said about payment of the fact finder is that the neutral fact finder we share together. I would assume that you'd pay your fact finder and we'd pay ours.
Yes, I think that was what the intention was.
Okay. Then if you look at C, issues for fact finder consideration, I went from our 10-day to your 14-day period for coming up with those things, and I again added at your request, only mandatory subject of bargaining submitted to fact finding unless the parties mutually agree. Scheduling the fact finding hearing. We're essentially in agreement. I went to your fact finding board. Now, in the conduct of the fact finding hearing, again, I used your language, you know, which was largely mine too, it looks like.
Yeah, I utilized I really looked at what you had placed on the impasse and tried to incorporate it with what you were proposing.
Yeah, and I appreciate that. The factors affecting the fact-finding board's recommendation, I didn't put everything in your proposal. I did change wages to total compensation. I did say that, you know, there was one in yours, and I'm sorry I don't have yours. There was one that you added that I didn't understand and I didn't add. But when you look at it, you may be able to. Hang on a second, I'll tell you which one it was.
Is it the equity one?
Is y'all's impasse at the very end or something?
It's on page, well, if you look at the one I just sent you, it's on page, the laundry list is on page 33. That's the 1 p.m. version of today's.
Yeah, that's it. The equity of the total compensation plans within the city of Corpus Christi. Does that mean comparing us to other, like to civilian employees and?
Well, what it really wants to take into account is the total budget and the total compensation plans we have across the board for the entire city, including, you know, that would be everybody, police, general employees, fire.
You know, I mean, that's a two-edged sword. I mean, if you know, the police have done a better job in bargaining than we have, that cuts against you. If it opens the door for us to request, like, let's see the city manager's total compensation package, because that's part of it, and what proportion. How does the city manager and the assistant city managers, how do their wages and total compensation? It seems to me like, it's no secret that often public safety budgets are a large portion of what a city pays. So
think
I
that-
left it out of there, but
Okay.
I guess I'm inviting discussion about how that could be an important factor.
I think the real intent was, with regard to the budget across the board, the total budget for the city, and maybe there's a better way to explain that. But we'll look at that and,
Okay.
we'll counter propose to that.
Okay.
And explain a little, maybe I can write it a little bit better.
No,
So-
and then the fact finder's recommendation, I think that this is where we're still in a little bit of disagreement, and we talked about this last time. I'm hoping that we won't, I would rather the fact finders not make an all, just pick one as opposed to the other. And the reason is that I want the two parties at fact finding to have feedback. Well, Craig, your proposals on Article 1 and 4 were pretty good and reasonable, but you're out of line on Article 5, so I'm going with the city on that. Then when I'm looking after fact finding, I'm looking at the decision and getting that feedback, it makes me say, well, okay, I gotta do something about Article 5, I'm out of line here. But if it's just an all or nothing, I'm not really gonna get that feedback. And so my hope is by having them do it article by article, and I'm not talking about just like, little micro issue by micro, but just article by article, that we get feedback that we can use to get as much agreement on as much as we possibly can. So that's what I'm asking y'all to consider. That I think is the only big area where we're remain in dispute.
And let me just let you know my concern as to why we were kind of going down that road and trying to open up this kind of discussion. My concern is that if we go, and I hadn't heard you say article by article. I heard you say issue by issue, which could be micro issues.
Yeah.
My concern is, even though we're going issue by issue, and we tell the fact finder not to split the baby, essentially they can't. And that's something that I would like to prevent them from feeling like they have to give some to the city and some to the union, and that's the concern I have. And
See, but you're gonna have, that's the beauty, and I think that's where your proposal really was better than mine, was that you got your own advocate on that 3-person panel, and we've got our advocate. And so when they're talking to make their decision, everybody's gonna be able to get feedback on if they're doing that, if they're trying to split the baby
Right.
with the bathwater. This is not a hidden process to us, because we've got our advocates on that panel.
Right.
So I think that's a built-in protection against that kind of concern, and you'll know, okay, it's not really valid feedback, because he's just trying to throw the dog a bone there,
yeah.
sort of thing. So.
And one of the things is, and I'll take that into consideration when we're doing our counter proposal, because those are very valid points, and it starts to get very technical and very tedious, and we really need and want this process to work in order to be able to make this process, go more efficiently,
Yeah.
be more fair and equitable, and end in a timely, end a little bit more timely, and end in a contract. One thing I was trying to do is make the mediation a little bit more meaningful as well.
The mediation before fact-finding?
Before fact-finding. Because if we're forced to already kind of put our packages, and I'm just saying, giving you what my thought process was and my reasoning for kind of developing in this manner, if we're forced at that point during fact-finding to already package it, then mediation has a lot more meaning. We get a lot more feedback from each other and the mediator. It forces us to do that. It forces us to be more reasonable and to actually come closer to the middle before we even get to fact-finding. So if you have another, another mechanism that would help us do that, that's my incentive behind why I did it, why I proposed it this way.
Okay.
But I'll look at it again.
Yeah,
and see,
because
play
I
with it a little bit.
think ultimately it may in other words, instead of like going down like this, it's just
Right,
you know.
funnel it too quickly.
Yeah, funnel it
Okay.
too quickly, and we don't, and we're losing information. Because, I mean, our goal is the same, to get information to the parties so they can understand if they're being reasonable and can move towards the middle. Because when you get to that arbitration, it's all or nothing.
That's all or nothing at that end, yeah.
Um,
Okay, we'll look at it.
So, the party meeting on the fact-finding board's recommendation, pretty much we were in agreement on that. Then when you get to the binding arbitration, I did adopt your language here. Instead of, just going on a written record, I've agreed to do a second hearing. I've agreed to the 3-person, panel concept. I've agreed to the winner-take-all concept. I've used your 14, where you see changes in dates. Those are me coming to you.
Okay.
For example, you had we exchange our packages. I had it where we just exchange our packages and then we got a chance to change them one more time. And it goes to the arbitrator. You wanted to meet, look at each other's packages, and then have an additional time period to make additional changes, and then do a hearing. And I just went with you totally. Okay, so this process on binding arbitration is pretty much yours, including if you look at the bottom of page 4, all that language is from your proposal. I may have changed a word or two.
Okay.
But, the only thing I did change, if you look at the, I think you had like a substantial evidence review of the arbitrator's decision, and because it's an all or nothing thing, I didn't know how that would work, and so I used the old legally insufficient standard, the Texas courts, legal and factual insufficiency. Legally insufficient is a more difficult standard to attain. I don't want to be seen as trying to hide the ball. I mean, it's just like, the arbitrator's just kind of, not pulling it out of any factual basis at all. They're just, there's not a scintilla of evidence to
Is that
support.
on the bottom of page 35? Because I'm
It's
looking 3 sentences up and I still see substantial evidence on
That's
there.
your proposal, but my proposal, I say, that's where I
Oh,
made a change.
I'm sorry.
My proposal uses,
I had
instead of
moved on to the
substantial
wrong-
evidence, legally insufficient,
There it is.
okay, based on the whole record.
Okay.
Because remember that, we're picking all of one person's proposal or another. And so, my proposal in Article 5 really may be a lot better than yours, but your overall package was slightly better than mine. So when I could say, well, they went with the city in Article 5 and there's no substantial evidence to
Yeah.
support that, but the truth is that, well, maybe not that, but if you look at the record as a whole and the whole package,
Mhm.
so that's why
Okay, that makes
okay.
sense.
And then the resulting successor agreement, that.
I've had to deal with that in appeals, so that totally, the insufficient standard makes sense.
Yeah, okay. So anyway, y'all, I think we're really close on that one.
One of the things
Unless y'all have any other questions or.
No, not right now, and one thing I do want to point out is that what we have done through our proposal is we're guaranteeing a contract at the end, which we're not legally required to do.
Absolutely not.
And it's a big give from the city council and from the city.
It is.
And
I don't deny from it.
right, and so I just wanted to make that clear, that we're putting that on the table. We know that we're not bound legally. Our only duty is to collectively bargain, but our interest, as it always has been, is to come to a labor contract with you. And we're showing, and do it in good faith. And so we want to make sure that you understand that this is kind of we're putting a big fish on the, on the table.
No, I do
So,
understand that.
okay.
I do understand that. I think it's, and it's been very well received on our side, and we think it's a huge step in the right direction. And, I mean, the whole goal is to prevent, labor strife, right? And I think it says a lot towards the city's commitment to doing that.
Okay.
Moving towards Article 24, grievance procedure. When we get to the logistics, we're almost entirely in agreement. Where I think that we're still having trouble is with the very start, in the section that of your proposal that you've entitled, purpose and scope, and you have a laundry list of, bullet points and things that have to be included. And, I've left most of that out of my proposal, and it's not, intended to indicate that we didn't really consider what you're doing. But you have to understand that from our side, I'm a lawyer, fully admitted. I'm proud of it, although others would say I shouldn't be. But I'm not here for these guys very much. They use mostly lay officials, and especially in administering the lower levels of the grievance procedure. And a lot of these appear just to be gotchas, because like, one of the laundry lists is, put the date of the grievance and the date the alleged violation occurred. And let's say they forgot to do one of those. Then it says, well, if it's not filed in accordance with the provisions of this article, it doesn't meet the definition of grievance, which means we can't arbitrate it.
And just as a point of reference, we didn't intend to put these, it's not a trick, it's not a trap or anything. A lot of these things are addressing issues that we have previously dealt with recently with regard to, a date, or for instance, when we're asking for memorandums of understanding they're relying on, they knew that there was a memorandum of understanding that they were relying on, but we didn't get it till right before the arbitration. We could have probably settled it right then and there. Things like that, and so we'll look at that, but
that's that sort of thing is a problem. However, I talked to my guys about that, and I don't want to put anybody on the spot, but certainly at a lower level of the grievance procedure, that MOU was brought out. And so it was a situation where we thought everybody knew about it. And I think that there may have been a communication error on your side. I don't know all the details, and I'm certainly not making any allegations. But all I am saying is that obviously we're agreeing to a grievance form. And the grievance form has spaces that need to be completed. And if you want to contend that that failure to fill in a blank.
Sometimes you may not have the information to fill in a blank, so that's not our intention,
Yeah. Okay, well, we'll look at it.
If you didn't know of an MOU at the time, and then one does come up, then as long as we get it in a timely manner, so we'll look at it and we'll work through that. But I see where your concerns are, but I hope that you also understand and appreciate the reasons that what we're trying to do is fix things that had become a problem for both sides, and we wanted to our goal is to make this grievance procedure work properly and work efficiently and be fair and equitable to both sides.
And I really think that it would. I mean, if you look at mine, if you look at the scope section, it makes clear that a grievance is only an alleged violation of provision of the agreement. And then I've added a sentence, if it's not a grievance under that definition, then it can't be submitted to grievance procedure, including arbitration for resolution. And so I kind of think that covers the waterfront. Then if you look at exclusions, it doesn't cover disciplinary actions, and it doesn't cover alleged violations of statutes or other law outside the agreement, unless those things are actually incorporated into the agreement. So I think all of that clearly limits the grievance procedure to its intended purpose. And then in terms of Section 2, initiation of the grievance, I've talked about association and individual grievances, and group and class action grievances. A lot of that language you agreed to. At your request, I've eliminated city grievances entirely. Then the grievance procedure itself, we're pretty largely in agreement. You had a step 6 in yours, which was the authority of the arbitrator. You'll find I've got the same language almost exactly. In fact, I added a sentence to it, but it's at Section 7 at the end. So I haven't eliminated it, it's just in a different place. But, so that's the steps of the grievance procedure. Again, Section 4, the grievance procedure for city grievances totally eliminated. So we won't have city grievances. I've eliminated the FMCS as a place where you can get the panels from. If you go on to page 4, all of this blue language almost is from your proposal. the stenographic transcription is your proposal. I've agreed to, we have a slight disagreement. You know, you put something in there that on-duty firefighters, you know, that are needed to testify need not be released by the fire chief, or can be released in his discretion. What I'm worried about, and I'm certainly not throwing stones at this fire chief, but a fire chief who, you know, might try to, you know, unlevel the playing field by on-duty witnesses not making them available to testify. And that's, you know, what I did was I changed our proposal though, so that, you know, I don't want it to cost the city any money. So just like when they go get their drug test or, you know, some test, you know, the whole crew travels with them. It could be that kind of thing, you know. All I say is you make them available to testify. It doesn't have to cost you any money.
Okay. Yeah, and one of the reasons for kind of starting to address that was we didn't want it to affect operations, we didn't want to, you know, affect overtime, all those other things that come into play, so I understand.
And we don't either. I mean, if it were some kind of grievance where a large number of on-duty personnel might be needed to testify, I think the parties could by agreement say, well, let's do some depositions or something, you know, and give that to the, you know, so that we can avoid that problem. I've incorporated all of your suggestions, I think, about exchanging the name of witnesses and exchanging exhibits. Okay, and the two weeks before the grievance hearing, we've got each other's witnesses and exhibits, so we kind of all know. We left in the language about arbitrator subpoenaing records. The changes that you see there are changes to kind of accord with your suggestions. Same with the discovery. If I've got your witnesses and exhibits, I may not need much discovery, but the discovery provision is there. The 4-week calendar, you got to do it 4 weeks before the hearing. That may make it kind of hard because, you know, we want the thing to be expeditious, and if the arbitrator's got a quick date, you know, we want to grab it.
Well, and I struggled with that week because I wanted it to be 2 weeks, but then if we have to go to the arbitrator and ask for them to compel it, and I did put in there a provision that discovery, and I didn't see if you kept that discovery shouldn't delay the hearing at all.
Yes.
And that was one of the reasons why I kind of kept that 4 weeks to allow for that process to occur if necessary. I don't see the discovery procedure being utilized very much because of the exchange of documents, exhibits, and witnesses. But it's there for the one time we need it, and the time is there for the one time we do need it. And the purpose isn't to delay the hearing at all. It's to make sure that all that stuff is done before we have the hearing set. And so that's why I left it. I struggled with that. I was trying to outline it and chart it out, and 4 weeks gives us just enough time to try and get it all settled on the discovery part before we go. But I don't see that really being a big issue. It's never really been.
I put in your brief provision, I changed it just a little bit. I'm looking at the top of page 5. Any party, I mean, you had it where the arbitrator could request briefs. And I said, so within 30 days after the conclusion of the hearing, or after receipt of closing briefs if requested. And what I'm envisioning is that any party could request briefs. Normally the arbitrator will say, do you want to do briefs? And if either party wants to do them, the arbitrator will say, well, let's have briefs. You know, so, but so that's that. And then on the arbitrator's authority, you had language in there, confine himself to issues submitted for arbitration. Shall have no authority to determine any issue not properly submitted by the parties. And I kept that language. I added a sentence. However, if the parties disagree as to the issues for decision, the arbitrator is authorized to frame the appropriate issue. Arbitrator is not adding issues, it's just that, you know, we can't agree on the wording.
Right.
And so the arbitrators, you know, as it often happens, well, will you let me frame, since y'all can't agree, will you let me frame it? And
in fact, we've done it on this contract for grievances and appeals, so.
Yeah.
That's.
And then again, that section 7, that's what you called step 6 of the grievance procedure, and all of that in black was language pretty much agreed to. The blue was the additional sentence you added, you put county court, I put district or county court, I'm aware that most cases
Concurrent
go to
jurisdiction.
county.
But it's concurrent jurisdiction,
Yeah.
it's just, that's fine.
Okay, so anyway, we are, I think, really close
Okay.
here too, so it would be great if we could, get a couple of these out. I've got proposals for you on work schedules and disciplinary hearings that are almost completed. It's, the time it is now, it probably doesn't make sense to go back to the caucus, but I'll have those for you to start it tomorrow.
Okay. And I was also gonna mention that, seeing as how I got these and we're gonna be working on this afternoon, tomorrow morning, even though we'll be here early, but the official start time for open deliberations is 9:30 if you're ready. We'll probably ask for some time before we come and sit down, just so we can have, give you some more counter proposals and be able to talk about them, a little bit more with, and be fruitful about it, so.
That's fine.
Okay.
That's fine.
So we'll visit in the first thing in the morning, but I anticipate we'd probably at least need an hour. I'm gonna try and get here really early so that we can shorten that time, but that'll allow us to do some more work before we sit
Okay.
down.
Okay, very good.
Okay?
We'll see y'all tomorrow.
Thank you very much. See you